infectious diseases, research, medicine, health. Welcome to Outbreak News Interviews. And now, broadcasting from the Outbreak News Skylar Studios in beautiful West Central Florida, here is your host, microbiologist and editor of OutbreakNewsToday.com, Robert Harriman.
Well, hey everybody, this is Robert, and welcome to Outbreak News Interviews. Now, years ago, I was introduced to a practice of law that focused on food safety. At that time, I didn't even know that existed. Now, more recently, I've learned of another practice of law called STD contraction. So joining me now to discuss this field and what the law says is attorney Todd Kelly. Mr. Kelly is a partner with the Carlson Law Firm in Texas. Mr. Kelly, thank you for joining me today.
Well, thank you for having me.
You bet. So STD contraction law, what is that?
Essentially, it's a case of assault and battery because it's done with the intent to gratify the sexual pleasure of the person who gives the disease. When we file these cases, at least under Texas law, we file them as sexual assault cases because without the consent, and consent, of course, must be knowing, you don't have informed consent if you don't know the person has a disease, and so you haven't consented to that level of touching.
So you mentioned that you practice in Texas. Are these laws pretty similar across all the states?
They are nuanced. They're similar in the jurisdictions in which I am familiar. I certainly can't speak for all 50 states.
Sure.
Certainly in the jurisdictions in which I'm familiar, the laws are pretty similar, and the definitions of assault and battery are almost the same in every jurisdiction.
Okay. So do you have a legal obligation to tell your partner that you have an STD? Yes.
As I stated, or as I alluded to earlier, without knowledge, a person can't consent. And so we all know that, again, sexual contact without consent amounts to an assault. And so that's what happens when you fail to disclose the fact that you're putting your partner at risk of a sexually transmitted disease.
Right.
And at least in the context of civil lawsuits in Texas, it doesn't prohibit the exposure as long as you've given consent. So, knowing is everything.
Right. So the next question really piggybacks on that. Is it against the law to knowingly infect someone or put them at risk of contracting an STD?
It is. There are both criminal codes as well as civil remedies for people that are infected because of another person's failure to disclose those infections prior to engaging in sexual contact.
So as an attorney, how do you prove liability?
Well, this can be difficult. It can get a little tricky, and sometimes it's just a he said, she said, because rarely are there witnesses. But sometimes people are incredibly open in their text messages and through emails, so the cases become very fact specific. Sometimes we've had victims who have gone through the bathroom cabinets and they've found medications that they know to be related to the treatment of a sexually transmitted disease after they've engaged in sexual contact, and that's how they discover it. So in those cases, we can prove that the defendant knew before engaging in sex what they were doing.
Okay. Now, this is, I imagine, typically a civil offense. Go ahead.
Go ahead. Normally, yes. Well, normally it is, but there are criminal charges that can be brought.
Exactly. Can you elaborate on that?
I can a little bit. I'm a civil lawyer, but there are criminal codes. Texas, for instance, has penal codes, Section 2202, which kind of deals with the HIV and AIDS epidemic, and basically says that anyone that knowingly infects another with that disease can be charged with assault with a deadly weapon. That deadly weapon, of course, being the disease.
Right.
And then there are, for the less deadly diseases, but still very traumatic, things like herpes, chlamydia, syphilis, hepatitis. There's assault charges for those too. They're considered lesser crimes than the assault with a deadly weapon, but still assaults.
Okay. In a kind of a different twist on the question, the fact that you have an STD is private and confidential, but say there's someone that has access to the info, your doctor or somebody in his office, and they disclose this without permission. Is this considered a crime?
I don't know that I'm qualified to say that it's a crime. It is a violation of the federal HIPAA law, however.
Right. Okay.
And because HIPAA violates disclosure, it prohibits disclosure of the information like that by a healthcare provider. If we get into litigation and we subpoena that information, that's one way that HIPAA can be is not violated, and the information can be given without violating that. But if they do so on their own, just even with the best of intentions, healthcare providers are probably crossing the lines.
Gotcha. And any final thoughts? Is there anything I left out that you think you should add?
One of the things that I think people probably don't realize is that, if your listeners, or some of your listeners just statistically will have been infected with one sexually transmitted disease or another, it's not the end of the world. I would encourage them to get help, seek legal help, but also to know that they need to get medical help. There's a lot of people, 1 in 4 people statistically in this country over the age of 18 have been diagnosed with one form or another of herpes.
Okay, very good. Well, I want to thank you, Mr. Todd Kelly, for this very interesting conversation. I appreciate it, sir.
You bet. Thank you for having me.